Court does call the case of People versus Julian Carey.
Here's what is appearing on behalf of People, Your Honor. Good afternoon, Your Honor.
All right. We're here on the motion, your motion for discovery, to compel discovery.
Yes, Your Honor. Should I begin?
Go ahead.
Yes, Your Honor. I moved for discovery of potentially exculpatory material under MCR 6.201. I made that request in July. The prosecution had 21 days to comply and did not provide anything or any response until very recently. Last night I received a response to my motion. I filed a reply today, Your Honor. I'm not sure if you had a chance to.
I read everything, counsel, so.
I know I do. So if you read everything, then you know what I'm asking for. And I'm asking for discovery of communications between the alleged victim, who's a fellow by the name of Will Hathaway, outgoing Scioto Township supervisor, and communications between he and members of the prosecution team, which include officers.
How do I know these exist?
Sorry, how do you know? Well, I believe they exist. I know for a fact that there are emails after the discovery was produced to me between the key detective in this is Detective Harvis. He's a quote-unquote computer expert in the case. And
Well, he's not quote unquote a computer expert. He's extremely skilled in what he does.
I'm sorry, I didn't
So
mean
go
to
ahead.
confuse him, but I don't know what his title is. I was just saying computer expert. But he has been having communications with Will Hathaway, who's the complaining victim, and also with members of the IT department of Scioto Township. There have been emails, there's written communications between witnesses, and
How do you know that?
because I learned that from my client because Mr. Hathaway was talking about emailing with this gentleman. I believe they exist, and Detective Parvis also came to the township and met with Mr. Hathaway, trying to follow up on the information that we provided to the prosecutor, showing why this case is completely a non-case, that there was no crime that occurred in this case. Not even a crime, let alone my client committing a crime. There wasn't a crime. An old email and an old meeting request were sent when my client clicked that.
I've read that, counsel. I'm just trying to figure out how I know these things exist.
You don't, Your Honor. You don't know until you look. And when I asked the prosecutor for this information, he said, on information and belief, I don't think they exist. That is not the proper response from the prosecutor, Your Honor, and you know that. The prosecutor's response should be, I checked with the sheriff's department, or I looked at these materials, or they don't exist. All I got was,
Well, what information and belief? Why, you may not like the response, but the response is his information would have had to come from somewhere. So you're talking what words he was using as opposed to anything else.
no, I don't think so. Respectfully.
Well, I do.
Okay, well, do you understand what I'm asking for?
Not really, because I don't know what documents you're saying exist that the prosecutor hasn't turned over.
Okay, I'm saying that there are emails for sure between Detective Parvis and Will Hathaway. He's a complaining victim, and I would ask for those emails to start. But I would ask for any written communications between any witnesses and the sheriff's department and the prosecutor's office.
Okay, so the only way you know that there are emails between Mr. Hathaway and Detective Parvis are because Mr. Hathaway said so?
I have a moment. I can tell you exactly. Can you give me 1 second?
Sure.
So, Your Honor, the way we know that they exist is because Will Hathaway forwarded those emails that he was having with the detective to another member of Scioto Township, another employee. That's how I know.
So where's that employee?
You asking for testimony from a witness?
I asked you a question.
Where is
the employee that says they got the emails?
Well,
they're not at work now, it's past 4 o'clock and we need to have them here.
So this employee received, I'm presuming, on their personal email or on the Scioto Township email?
Scioto Township, Your Honor.
So my question becomes, why would your client, if they exist, not have access to those through their IT department?
Anything to me.
My client has not been able to get access to that. And I don't think she's requested that.
Well, counsel, do you have have you tried to get them?
Have I tried to get them? Me?
Yeah.
I've done a FOIA for communications at the township, but this is stuff that happened more recently when I did the FOIA. And it's, Your Honor, with all due respect, this is exactly what the prosecutor should be doing, is finding out, are there communications between my witnesses and my police officers that are.
No, with all due respect, what you will do is you will answer my question.
I'll answer your
Have
question.
you attempted to try to get them?
No. I mean, I did by filing this motion. How else am I going to get discovery, Your Honor? I guess I'm confused by your question.
Shouldn't be confused by my question. Look, the prosecutor is not required to do what is really part of defense's job. Certainly, they must supply evidence that they have and comply with any reasonable requests. But you come here to me today, and I don't know that these things that you're requesting, whether they exist or not. And the only way that you know that they exist is because somebody has said that these were sent to somebody at Scioto Township, and that it's between Detective Parvis, presumably, and Scioto Township. So my question is, on that end, why don't, if they exist, when did this happen? You're saying it's recent, but when?
I can get you a date. Within the last 2 weeks. But it's not just that, Judge.
If I may.
I think I'm still arguing.
No, I'm just trying to clear up the point here.
No. We don't do it that way here.
Thank you.
Just for a bit of context, Your Honor, if I may. Mr. Boloda provided me with some information from some computer person Dave retained. And it had to do with a meeting invite that went out around the same time that this email went out. That information was emailed to me, and I don't know, because I'm not a computer expert, what it is that this information entails. I forwarded that information to Detective Parvis, and I've spoken with Detective Parvis. He's attempting to, I believe the term is the header information that is retained on the servers at Scioto Township. He's basically trying to vet that information, Your Honor. And so that has happened in the last few weeks, and perhaps in attempting to vet that information, Detective Parvis has been communicating with Scioto Township. I have no specific knowledge of that. I haven't been provided anything, but it wouldn't shock me that Detective Parvis is following up because I asked him to follow up. He told me that at some point he's going to provide a report to me. I don't have any sort of report, and I don't have any update for the court. I'm only saying that in as much as I am aware that Detective Parvis has been communicating with the IT department of Scioto Township over the last couple of weeks in response to information provided to me.
Okay, well, that's a big piece that's left out. So you provided something to the prosecutor's office.
Yes.
That your expert provided to you.
Yes.
And then from that, the prosecutor's office then sends that information to try to figure it out. So how do I get to their, and so that hasn't been completed yet.
I've not had an update or any reports. My understanding is the IT individual from Scioto Township, the primary person is out on some sort of leave. And the other information was that obviously with an election forthcoming, the current IT person has a lot going on. So there's a delay, I think, in getting that raw data to Detective Parvez so that he can, validate whether this is or is not true based on the defense side.
So, I mean, is there anything in that that's not true?
No. And
So why am I here if you, jeez, okay, if you gave them information and they're trying to unlock that information that you've given them, why am I here on a motion to compel that information where it's not been done yet?
because that's not what I'm not asking for a follow-up report. I'm asking for communications, Your Honor, and not just with Detective Parvez and the IT person, but most importantly between Will Hathaway and members of
Yeah, but doesn't that come from isn't that the subject matter of the meeting invite, or am I reading that wrong?
what is the subject? The meeting invite was for a meeting that happened 11 months or longer before. So it was an old meeting. That's why I say that this case was just essentially an IT issue. It had nothing to do with any individual action or anything. And that's why this case is served in this courtroom before you on this matter, because there is no evidence. And that's why I wanted to spend some time talking about the case to show you that the principal witness is Will Hathaway. He is a political rival of my client. My client was running for the position that he now holds for the time being, supervisor of Scioto Township. And he is a long-time political rival. So he's the one pushing this prosecution, Your Honor. He's the victim. He went to the sheriff and he's pushing this. So all of his communications with the prosecutor's office and with the sheriff, I believe I'm entitled to. And at the very least, I'm entitled to the court to make an in-camera determination as to whether there's anything exculpatory if they exist.
If they exist.
I know. This whole thing could be solved if the prosecutor had said in his response, I asked, and there aren't any. I asked the sheriff, and there aren't any emails. There aren't any texts. That's all he has to do, but he didn't say that. He said, on information and belief, I don't know about any. And that's just not enough. That's not enough.
So you wanted to use specific words?
Well, I mean, the Supreme Court said that he has a duty to investigate material within the possession of the police. And he's telling me that he doesn't think there is any, but he doesn't say that he even checked.
Okay, so let's presume this, counsel. You make the request. Mr. Childers goes to the police department. Police department says we don't have any. He then has to respond to you. He doesn't know that because he can't say they absolutely don't. He can only tell you what he's been told. So if that's all that he can say, he would have to say on information and belief, based upon, which is really going to be based upon conversations he's having, I don't have anything.
Understood. And I've been on that side, and all I would say is, look, I asked, and they don't have it. Okay? And maybe he did ask. I'd love to hear him say that he asked. But what I've heard from him, and I met with the prosecutor, Your Honor, is I heard from him that Will Hathaway made a contradictory statement to him, telling the prosecutor that he himself did not write the email that was sent, the untimely email. He had said
I can't get into evidence on the case. You're asking me, I mean, you keep throwing this stuff out there. I don't know if that's the evidence or it's not the evidence. I'm here on your motion, which is quite frankly improper in the way that you drafted this motion.
How so?
But because you lay out all of these things that, and quite frankly, counsel, made certain accusations against people in some conspiratorial sense that turned out not to be true. For example, you specifically stated that Patricia Reiser authorized the complaint. I went to the complaint. I looked at the complaint. She did not. And then that was before I got the response from the people because I didn't know for sure.
I didn't say that. I said that she worked there and that was her job, and that's factually accurate. And it,
No, then you misled the court because you made it seem, as the one's reading it, as though she's the one that's authorizing it. Don't tell me, counsel, what my impression of it was. And I think you intentionally tried to mislead me. I'm going to let you know that.
I did not.
Because that didn't happen.
That's good. I'm glad it didn't. It shouldn't happen. It shouldn't happen, but it also shouldn't happen.
You know what? You better sit down because you're going to learn real quick how to address this court. I don't play that way. I'm going to take a recess. You check yourself and then I'll come back. Court's in recess. Counsel, you've indicated emails between Hathaway and Parvis. What else are you looking for?
Thank you, Your Honor. And let me just apologize to the court. I know you took a recess, and I want to say I'm sorry. I did not mean to disrespect the court in any way. I apologize if my arguments came across that way. I would say it's probably due to my extreme belief that my client is absolutely innocent. I apologize for my zealousness, making me feel that I was being disrespectful. I very much apologize. Other things besides that, Your Honor, the communications between Will Hathaway himself and members of the prosecution team, including Parvis and Deputy Phillips, who's the officer in charge of the case. So that's what I'm asking for, communications. And I don't need to say anything more. I'll rely on my brief.
Well, no, I do have a question. How do I know these exist?
You don't. You don't. I only know what I've heard and what I've reported to the court. And what I was asking is for the prosecutor just to check. And maybe I misread his response. Maybe he was saying information belief means he checked. I just want to know if he looked and if there's nothing, then I'll.
Did you ask?
I asked for him and he said he wouldn't provide them. So they weren't discoverable during our.
Mr. Childers?
Yeah, and the problem, this is now like the third time in this hearing, as well as multiple instances in the pleadings, the defense is misrepresenting statements that I've made to the point where I don't feel comfortable speaking with the attorney absent being on the record or in writing. We've had phone conversations and somehow the subject of those phone conversations shows up in the pleadings inconsistent with what was actually said. There was a statement in the pleadings that the fact that the defendant passes private polygraph, I should act upon it, even though I specifically told the defense attorney that the only way we would do anything on the case is if she passed the police polygraph, because as this court knows, that standard procedure. That offer still stands, and Ms. Carey wants to avail herself to a police polygraph. Not only would I welcome that, I think that a result on that could be highly dispositive in a case like this. It's my understanding that she's not willing to do that. That's her right. That's fine. As far as my communication with respect to emails, the statement that I was responding to that I would not turn over would be internal emails in our office among the attorneys, because clearly that's work product and that would not be turned over. But in fact, in that conversation, what I told defense counsel was, candidly, there are no emails. I've never emailed with Mr. Hathaway. If I had, it wouldn't necessarily be discoverable. It could easily be work product, but those emails don't exist. I've never emailed with him. I didn't communicate with Chris Reiser in our office. Obviously, I wouldn't communicate with John Reiser, and to insinuate others is frankly, when I read the pleading, I had a thought to communicate with the bar regarding the ethics of the pleadings and the communication in this case. I am not aware of any email correspondence between Detective Parvez and Will Hathaway, and I'm not in possession of. Obviously, if there's a report that Detective Parvez produces, and that report insinuates or includes those emails, those will be turned over. If the report reads as if there was email correspondence between Detective Parvez and Mr. Hathaway, I will ask Detective Parvez, please attach those emails in your report, and I will tender them. The court is well aware of the work product that I do and the ethics that I hold and how the fact that in this case, the allegations that this is some grand conspiracy is
The courtroom session begins with a tense legal battle in the case of People versus Julian, where the defense attorney presents a motion to compel discovery. The defense argues that the prosecution failed to provide potentially exculpatory evidence within the required time frame after the request was first made in July. According to the defense, the prosecution had 21 days to comply, but did not respond until the night before the hearing. The attorney insists that certain communications likely exist between the alleged victim, Will Hathaway, who is described as a political rival of the defendant, and members of the investigation team, including a detective involved in the case. The defense claims these communications may reveal information that could prove the defendant's innocence, or at least expose weaknesses in the prosecution's narrative. However, the judge quickly begins pressing the defense on a critical issue: how the attorney knows these communications actually exist. The attorney admits that the information is largely based on what he was told by others, particularly the defendant and individuals within the township who allegedly saw or received forwarded emails. This admission immediately raises concerns for the judge, who repeatedly challenges the attorney's reliance on speculation rather than concrete proof. The judge stresses that a motion to compel discovery cannot be based on mere assumptions or hearsay, but must be supported by a clear indication that specific evidence exists and is being withheld. The defense attempts to justify the request by explaining that the alleged victim had previously forwarded emails to another township employee, suggesting there must be correspondence between investigators and witnesses. Yet when the judge asks why the defense has not attempted to obtain those emails directly from the township's information technology department or through other legal channels such as subpoenas or records requests, the attorney struggles to provide a convincing explanation. The judge emphasizes that the prosecution is only obligated to produce evidence that actually exists and is within its possession or control, not to conduct broad investigations on behalf of the defense. At this point, the prosecutor steps in to clarify the situation, explaining that the defense recently provided technical data from a computer expert. Because of this new information, investigators are currently reviewing server records and attempting to analyze digital metadata to determine whether any relevant communications exist. The prosecutor states that the investigation into this data is still ongoing and that no report has been completed yet. He assures the court that if any report eventually references emails or other communications relevant to the case, those materials will be turned over to the defense as required by law. The judge begins to see the situation differently once this context becomes clear. Instead of evidence being deliberately hidden, it appears that the defense's own newly submitted information triggered a follow-up investigation that is still in progress. The judge questions why the defense filed such an aggressive motion, while the investigation into the data was still underway. From the judge's perspective, it would have made more sense to wait for the analysis to be completed before accusing the prosecution of withholding evidence. As the hearing continues, the judge also expresses concern about the tone and language used in the defense motion, which suggests that members of the prosecutor's office and investigators may have been involved in misconduct or bias. The judge warns that making serious accusations against legal professionals without solid evidence is dangerous and potentially damaging to credibility in court. While acknowledging that attorneys must vigorously defend their clients, the judge stresses that speculation about conspiracies or misconduct cannot replace factual proof. The first half of the hearing therefore becomes less about the alleged crime itself and more about the legal standards governing discovery, professional conduct, and the responsibility attorneys have when presenting accusations in court. By the end of this portion of the hearing, tension in the courtroom has clearly risen, with the judge signaling that the defense's argument may be built on assumptions rather than verifiable facts.